Starting now our Friday group 151, today's Friday group meeting. The speaker is Mr. Justice Retired A. Hari Prasad, Senior Advocate. Now he retired from Kerala High Court. The today's topic is ad hoc arbitration and institutional arbitration, merits and demerits. This is the topic. So because of Convilker's retirement, we are holding up to 350 only today. Sir, we will go one by one introduction. Myself, G.Seshagiri. Introduction. Quickly.
Shekhar Picha. I am Janardhan.
Shravan Kumar, sir.
Rahul Sharma.
Muthu Kumar.
Rahul Kumar.
Ajit Kulsresh.
Yeah, introduce yourself.
Introduction.
I'm visible there.
Yeah, it's
I am.
you both of you. Last. Oh. Yeah. Okay.
Brief introduction about myself.
Please.
I'll do that.
Good, sir.
I am Hari Prasad, presently a senior advocate among you. I was a judge at the Kerala High Court. Before that, I was directly recruited as a district judge in the year 1995. I was a service judge there. And I worked at various stations in Kerala, in various districts, almost 10 years. Then 5 years, I was the director of the Kerala Judicial Academy, where judges are trained for in-service and recruitment trainings. And then 2 years, I worked as the registrar of the Kerala High Court. Thereafter, I was elevated, and now, after completing 8.5 years in the High Court, Kerala High Court, after retirement, I have joined here, this esteemed bar. I am among you right now. And I am a third generation lawyer, and my daughter Swati is the fourth generation. So, back to home, that's my experience now. Deputation for some time on the bench, and thereafter, your natural home, you have come back. Thank you for the opportunity. I should thank Mr. G.Seshagiri Rao and Mr. Basant, Senior Advocate, for giving me an opportunity. And in fact, Basant introduced me to dear Sheshu, and I'm extremely thankful for this opportunity.
Welcome, sir. Yes, sir.
Shall we go to the topic?
Please, sir, straight.
Okay. Today's subject, the merits and demerits of ad hoc arbitration and institutional arbitration, is actually a most discussed relevant subject nowadays. Because there is a belief that India is not an arbitration-free country. Actually, because of so many factors that we will see later, there is a general perception that India is not a very fertile ground for arbitration because of the procedural and other expense. So many factors are there. Now, the concept of arbitration, as all of us know, was there in the 1940 Arbitration Act, which was more court-centric, because you have to get the award endorsed by the court, and so every instance you have to have the interference of court, which was a slow process. And Section 89 CPC, originally as it stood, was repealed by the 1940 Act of the Indian Arbitration Act 1940, repealed Section 89. Now, by way of 1999 amendment, which came into force in the year 2002, Section 89 was reintroduced, where the thrust is given for mediation, arbitration, conciliation, and judicial settlement, and of course negotiation is also possible. Now, these are the alternative dispute resolution methods. Now we have provided for ourselves under this statute. The essential difference between mediation, arbitration, conciliation on one hand and negotiation on the other is that for negotiation, probably intervention of a neutral third person may not be required. The parties themselves can do it. Whereas in the case of arbitration, conciliation, mediation, a neutral third person's interference is required. So with that understanding, probably if you analyze these alternative redressal methods, you will understand that arbitration is almost close to court proceedings. Because in other matters, there is only some discussion, some persuasions, some instigations, some methods to see that they are coming to an amicable settlement. Whereas in the case of arbitration, you take evidence, you hear the questions of law, and then decide the case by way of an award. So this is close to a court proceeding, and one of the other difference is that in a mediation, suppose it is referred to a mediation center, if it is not settled, of course I am speaking about a court case, it will revert back to the court. But in the case of arbitration, if it goes out of court, it is gone forever, it will never come back. So in that way, arbitration is more effective, and maybe it's a different channel altogether. But the complaint that India is not an arbitration friendly country was alarming the not only the superior courts but also the government also. So they set up a committee, Justice Sri Krishna committee. It submitted a report later, and what the mandate of the committee was to study the roadblocks of arbitration in this country. Now, lot of suggestions have been made by the committee that of course we will see later. Then India being a signatory to the United Nations Commission on International Trade Law, that is the basis on which we enacted the Arbitration Conciliation Act 1996. But still there are certain problems with respect to the Act. Why? Because Section 5 of the Act says that there shall be minimum judicial intervention. But even though that is the spirit of the enactment, minimum judicial intervention, so that the arbitration, the avowed object of arbitration is to have a speedy disposal of the case with minimum expense. But that always get entangled in various litigations. Section 9, for example, in the Arbitration Act, interim orders are passed by the district court. The principal civil court of original jurisdiction means district court. Then it is taken to high court. So that is one block. Then after passing an award, there are 7 grounds in Section 34 of the Arbitration Act which are available for a party to seek a recourse to arbitrary award. 5 of them are to be proved by the party, and 2 of them legal grounds which court can take cognizance from the materials available. So that is also another reason for delaying the process, because setting aside award and then appeal, so many Section 37 appeal. So these issues probably that worried the lawmakers. That is why Sri Krishna Commission was engaged. The report of high-level committee to review the institutionalization of arbitration mechanism in India. That is the caption given to that body. And EC means for resolution of commercial disputes was the thrust, because as we globally grow, there shall not be a bad reputation for the country that this is a difficult place where you have to have trade and business. So no foreigner will come here for doing business. Now foreign companies will be reluctant to come here. So just to avoid that bad reputation, probably thrust was on the international commercial arbitration and the dispute resolution. And the government of India wanted to send out a message that India is an arbitration friendly country. That is also one of the messages. Then, during the currency of this study, we find there is an amendment to CPC whereby the Commercial Courts Act are established by the 2015 amendment to CPC. That is one way to get rid of the the backlog of cases pending in various courts relating to commercial disputes. So that was also a step forward for disposing of commercial disputes on a faster rate rather. Then the committee was given some mandates. 1. Quick and effective resolution of commercial disputes through arbitration. That was the first mandate. Second, effective conduct of international and domestic arbitration. Study about that. How do you conduct effectively domestic as well as international arbitrations? Terms of reference included many things, and the main thrust was to suggest institutional arbitration in India. So these are the background in which these concepts we have to understand. Now, let us understand the simple meaning of the expression ad hoc arbitration and institutional arbitration. Ad hoc arbitration means it is an arbitration process either the parties themselves can initiate. Suppose A and B have a dispute over a thing, or there is a contract where an arbitration clause is provided. They can name an arbitrator by themselves and repose confidence in and ask him to resolve the dispute, which will be binding on them. That is the simplest form of arbitration. It's called ad hoc arbitration. Then the institutional arbitration, you find at least Justice Sri Krishna Commission report says about 31 institutions across the country are available at that time. Now it must have been increased. I do not know the exact number, but then lot of institutions are available in this country for institutionalized arbitration. Every institution may have its own set procedure and rules. They need not follow CPC in all cases. They need not apply the principles of Contract Act in a commercial resolution. They can have their own procedure and rules applicable. If the parties understand this institution is governed by such and such rules beforehand, they can opt for that institution if they are so willing. They have a choice. What I am trying to say is that they have a choice. Knowing the rules and regulations, they can go before the institution, get the service of that institution for resolving their disputes. We will see the merits and demerits later. Then if you look at the Justice Sri Krishna Commission report, you will find it is in 3 parts. First part deals with the institutional arbitration, and it's a threadbare study of the current state of institutional arbitration in India, the facilities available in such institutions, whether they are adequate or not. These are all well studied in the first part. Second part is this case study of International Center for Alternative Dispute Resolution established in this country. That is the second part. Then third is role of arbitrations in the bilateral investment treaties, that is nations. When there are treaties between 2 nations, bilateral treaties, how they are worked out, that is the third part. So divided in 3 parts. Actually in our subject, we are only concerned with the first part, chapter 3 of the report. It says, and before that I'll just put a definition of, going by the Sri Krishna report, I'll just put a definition as to what is institutional arbitration. It says, administration of arbitration by an institution in accordance with the rules of procedure set by the institution itself. So that is a kind of administration of arbitration by an institution under the supervision of an institution. The advantage of this institutional arbitration is that you will have a set rules, so there will be certainty as to the procedure. And second thing, you will have a panel of arbitrators, because the domain expert, suppose it is some company involved in this computer manufacturing, technical experts must be there. You can't, lawyers or judges cannot sit and arbitrate matters where technical know-how is to be there. Infrastructure development, civil engineers may be required. So they have a panel of arbitrators. So if the panel is, the capable persons are named in the panel, that will be an advantage to the parties approaching the institution to get a effective resolution of the dispute. Then, and see, in many institutions you will find a body to oversee the arbitral proceedings, so that procedural mistakes will be rectified then and there. So it may not lead to 34 and 37 disputes later. So that is one advantage of institutional arbitration. Then of course ad hoc arbitration has its own merits that we will see. Then what is the situation in India? According to Justice Sri Krishna, he says there are a lot of pitfalls in the present system available in India. One is lack of credible institutions. That is the basic problem. There are a lot of institutions in this country operating as this arbitration centers, but most of them lack credibility. Why? Because that is quality of legal persons or quality of technicians employed there as arbitrators. They do not inspire confidence in the mind of many people. So credibility of an arbitrator, because all of us know that arbitrator is a private judge chosen by the party. Once I file a suit before the lowest court or in the highest court, I have no choice as to who should hear it. But in the case of an arbitral proceedings, the party has a choice to find out his own judge for deciding the cause. If the panel is not competent persons, then he will be desperate. He will be very reluctant to go to such center. So that is one of the lack of credibility area. Second, many arbitral institutions do not have exposure to best practices, international practices. Because normally for institutional arbitration, people go if there is a high stake in the matter. Not for small amounts, they may not go, because you have to incur a lot of expense for institutional arbitration. When there is stake is involved, there will be questions or these disputes will be in a larger scale. So this lack of exposure to best practices prevailing all over the globe, if that is not known to the arbitrators, their quality will be affected for that. Then Then the rules, as I told you earlier, rules of procedure is already set in the institutional arbitration proceedings. If the rules are obsolete or not according to the tune of the need of the hour or attuned according to the times, then that will be also a reason for parties, that will also deter the parties from going to such institutions. Then of course some institutions may be lacking infrastructure, like see the disputes take place. Now we are, after COVID, we are all familiar with this video conferences and all these things. Maybe just as Sri Krishna says, many institutions lack in infrastructure like distant dispute resolution machinery or infrastructure. That is also a reason for the lack of credibility of institution arbitration. Then another ground is misconception about the institutional arbitrations. Some misconceptions. One, the main misconception is about the cost, because once you go for an arbitration in a institution, you will have to pay the arbitrators, you will have to pay for the procedural aspects, you will have to pay consultation fee, whatever it is. So the cost will be normally high. If suppose you go for an ad hoc arbitrator, you can decide as to what should be the fee to be paid. So that is one misconception. But just as Sri Krishna says, there are institutions doing arbitration for a reasonable amount. That shall not be forgotten. That is what His Lordship says in that. But then this is the general misconception among public, that such institutions are exorbitantly charging. Then another misconception is that, as I told you earlier, there are set rules for arbitration in the centers. Now some people think that the setting rules is a difficult thing for them, because otherwise they will be free to opt for their own rules. If you are asked to go in a particular channel, some people may be happy because they may go in that channel, but others may think that, why, if I have an option to have my own procedure, why should I go for a rigid procedure set by the institutions? So that is also a misconception which the committee says it can be discussed and it can be found out as to the procedure also. Then another important area about the lack of credibility is lack of government support. Justice Sri Krishna says that lack of government support is evident. Even the contracts signed by PSUs like BHEL, take any EOC, whatever it is, even that agreements do not provide for institutional arbitration. They provide for arbitration, but they do not insist on institutional arbitration, because they do not name an institution. They do not give a suggestion as to institutional arbitration is the course to be adopted. So parties will have a leverage to go for ad hoc arbitration even in the case of PSUs. So that is lack of government support. That is one area where you have to improve. Then lack of statutory backing. If you look into the Arbitration and Conciliation Act, you will not find any suggestion or any indication asking you to go for institutional arbitration in such and such cases or ad hoc arbitration in the other cases. It only says about arbitration, which course no suggestion or hint given in the statute. So that is another reason for that. Then Justice Sri Krishna says, in contrast, if you go to Singapore, there is an arbitral body called Singapore International Arbitration Center, SICA for short. That body is the default appointing authority for arbitration in respect of commercial disputes. Instead of going under section 11 before the High Court or the Supreme Court, you can suppose you are not parties are not agreeable for a named arbitrator, the body will be the default agency for appointing an arbitrator. So it's a simplified procedure. We don't have such a system here. Same thing is in the Hong Kong also. You find a body, Hong Kong International Arbitration Center is there. Many countries, Oriental countries also have, Western countries also have. So such a this mechanism is not provided for in the Act or anywhere in the judicial system. So these are the areas where, then of course, another thing is judicial attitude, because as I told you earlier, section 34 there are 7 grounds. 5 are to be pleaded and proved by the party and 7 by the court. There is one decision, if I remember correctly, rendered by Honorable Mr. Justice M.R. Shaw in SAW Pipes, SAW, SAW Pipes, 2003 Supreme Court, a year 2003 Supreme Court, one decision which says that there is an expression in section 34 any award opposed to public policy of India, which is liable to be set aside. So what is public policy of India? We do not find a definition for this expression in any statute. Public policy is a term known to all of us, but if you ask me to explain it, I will find it very difficult to explain it because it depends from facts to facts. So public policy is a wide term. Anything and everything can be brought into the sweep of public policy. So virtually every arbitration award is exposed to a danger of being set aside, saying that it is opposed to public policy. And one more, there is one aspect also, madam, I will tell you that public policy of India, going by the decision, any decision taken opposed to the statute in India will be opposed to public policy. So statutory policy is equated to public policy in that decision, whereby an award passed, even courts are writing judgment against law. It is of course taken to appeal or to a higher forum, that's a different issue. Courts are having the freedom to write wrong judgment and right judgment. Courts are supposed to write judgment, but it is possible to have wrong judgment. That is why we are in appeal or revision or writ petition, SLP, whatever it is. So if an arbitral award is set aside, finding that it is opposed to public policy, which is equal to the non-adherence to the statutory principle, every award is at risk of being set aside. So this is an uncertainty probably. These are all factors repelling others from coming to India for an arbitration. Now, these are the areas where this Justice Sri Krishna made his recommendations to improve the institutional arbitration. And of course, amendment to the Arbitration Act was also suggested in that. Then coming to ad hoc arbitration, as I told you earlier, ad hoc arbitration is easy for the parties to decide on an arbitrator if they are in talking terms, if they are able to meet each other and sit across a table and decide. Suppose they are not able to do that by themselves, one of the parties can go to the High Court or the Supreme Court, get an arbitrator appointed under the provisions of the Act. Section 11 is the provision for that. So even if an arbitrator is appointed under the through the judicial intervention, he will be evolving his own procedure, and unless of course if the parties say that it should be in accordance to CPC or in accordance to the evidence should be taken according to Evidence Act, the parties have a right to say, but normally they don't say, because the rigidity of Evidence Act is not applicable. You produce documents in the if you go by Evidence Act, there is primary evidence, secondary evidence, all these rules. If you start complying with the object of arbitration will be defeated. So parties are free to agree on a procedure, and the arbitrator also has the wisdom to tell the parties, look here, I am going to follow in this way. But the problem is that in ad hoc arbitration, the parties must have some idea about the arbitral proceedings, otherwise they will find it difficult. So that expertise or a little bit of knowledge about arbitration is a precondition for an arbitration in ad hoc arbitration. Otherwise parties may not be able to suggest which rule should be followed. So they must have some acumen about that. But in the case of institutional arbitration, you just walk into the institution, understand the rules, go for arbitration, do it. So that is the advantage of that. Then of course there is some element of saving money in an ad hoc arbitration, because even the fees payable to arbitrator can be negotiated. But in institutions you will not have the freedom for that, because they have a set fee for that. That is one advantage of ad hoc arbitration. Then parties can select the venue, parties can select the time of arbitration, date of arbitration, venue, all this. Of course, institution may provide, but then there will be some difficulty in getting the convenient date for the party. As in the case of court cases, you find we may make a request to the court to post it on a day, need not be on that day. But in the case of ad hoc arbitration, they are having the domain over that every aspect of arbitration. Then the demerits of ad hoc arbitration is that actually the arbitrator chosen by the parties, if he lacks credibility, if he lacks knowledge, if he lacks this capacity to decide, then there is a possibility of having lot of mistakes in the award, for which 34 or other provisions may come into play. Whereas in the case of institutional arbitration, there is a body to oversee the proceedings, not only on the procedural aspects, but even the award before signing it, it will be scrutinized by a committee to avoid possible mistakes. There is no rule that, there is no guarantee that it will be completely flawless, but then to the extent possible, there will be another body to oversee the proceedings and the culmination of award. Then though the flexibility, responsibility of the arbitrator, etc., are the benefits of ad hoc arbitration, certainty and what you call this, the guarantee that it is devoid of mistakes are the assurances in a institutional arbitration. So these are the pros and cons of both these aspects. And of course, it depends on the case. Suppose it's an individual dispute. Let us take a partnership. Two persons enter into a partnership arrangement. After some time, there is some dispute arising between the parties. No, if either they can settle the dispute sitting across the table, or they can go for a person of their choice as arbitrator for doing that. If they are taken to an institution, probably it will be disproportionately high amount that may be spending on that. So depending on the nature of the dispute, nature of the parties, the rights of the parties, we have to decide whether institutional arbitration or ad hoc arbitration is suited for the given case. So both have to exist, coexist side by side. You can't say that ad hoc arbitration should be abolished. No, it has to exist, because, for example, somebody was telling last time that this hire purchase, a lot of hire purchase agreements are executed by public, private financiers for vehicle loan and other things. There will be an arbitration clause in the agreement. The poor person who takes the loan may not be knowing it, because there will be 200, 300 clauses, and in the middle there will be some arbitration clause also. So that arbitration clause, they will name the arbitrator of their choice. This poor fellow, without understanding, signs it, and then when there is a default, he is catching up. Such persons may not go for institutional arbitration. Why? Because they have actually muffled the borrower. They have smothered the borrower. He has no other option but to go for ad hoc arbitration. These are forced situations where you go for ad hoc arbitrations. But in the case of a public sector undertaking, it's a huge, lot of disputes, high stake involved. Then always it is better to go for an institutional arbitration, because there will be an expert body to decide the disputes. Various aspects, various facets of the disputes can be decided. So to sum up this aspect, probably I may say that institutional arbitration and ad hoc arbitration must coexist in this country. But institutional arbitration must be improved based on this report by Justice Sri Krishna, where the parties will have the confidence, instead of litigating for a long time in various courts at various levels, in various tiers. If they are able to get a remedy as quick as possible and without spending that much money, then institutional arbitration will be taken, will be preferred, no doubt about it. And as in the case of other countries like Singapore and other places where this is the, in the international commercial arbitration, this is the rule. It's not an exception. Here there is no rigidity of rule. If you are willing, you can go. But there some change has to be done. That is what the recommendation. And this appears to be the cardinal distinctions and this aspect with respect to institutional arbitration and ad hoc arbitration. Both has to coexist. And depending on the nature of the litigation or the dispute, the parties will have to prefer both. In both cases, quality has to be improved. Otherwise, this will not be a substitute for litigation in the court. I think I have covered the subject in time. Maybe earlier.
You can continue, sir.
No, I think if there is any interaction.
Yeah, please. Question, answers.
I have a small question, sir.
Please.
Mostly the disputes arises because the agreement of the contract is very vague as dispute redressal is there.
Right.
Like some institution using some private party, they will give you a dotted line to sign. That arbitration will be done by their own man.
Sir, even by railway you find.
Yeah, that's all institutions, army or the estate office or something, and it's a daily job they're doing. Hiring building and sign here, banks are hiring, sign here, it's a dotted line, there is no scope. Where is it there any institution or is there a need for the law when every agreement or the contract has to be vetted or approved so that you can work on to that? Till such time you should not allow, because 20 to 30% of business goes waste because there is a dispute. Very high level, very high stakes internationally or otherwise. So what is your suggestion and what is the mechanism available, we would like to know.
Sir, probably I may answer this question in this way, because entering contract is the pure in the absolute discretion of the parties. There are some decisions by this court, 70s you will find. Contract is the domain of the parties. You can't interdict or you can't direct. You can't have a mandate as to what should be signed, what should be done. So unless the parties sit with open eyes and understand the consequence and enter into a contract, no governmental agency, no statute can compel that it should be signed like this, because it's their bargaining power. See, every contract is the product of a discussion, give and take. So they understand it. Law presumes that they understand the consequences and then sign the agreement. So I think it may be.
My question is there only. It is presumed that they are good parties, but the disputes do occur. Only one part where I want that the government, the system, or there has to be some mechanism that this aspect has to be covered, and these are the one. The rest is up to you. You want to sell this and that or whatever it is.
I understand
But
your
to
question.
reduce the dispute, you have to have that inoculation or immunization or whatever you say, that this aspect has to be taken care so that the issue itself doesn't become a dispute.
Right? No, that of course that remains a wishful
Can there be
thinking.
law that everything has to be that part, the dispute redressal? Because if you are friend, no problem, nobody is bothered. You both earn and enjoy.
When
Everything
you are
is fine.
friends, there is no dispute.
Yes, sir. So for divorce, there has to be law. And before that, there has to be mechanism what should be treated as a marriage of a business.
Right.
That's what I want to know.
See, even actual marriages get strained. So there is no wonder the commercial transactions get strained. So,
Sir,
yes, please.
sir, because most of the contract, like you said that in the banks, there is a sole arbitrator from the department.
Correct.
And
How can
nowadays
he be
there are
impartial?
there are conflicting judgments of this court, and I think matter has been referred to the larger bench also. So, Lord, sir, basically when there is a sole arbitrator, you don't get the relief. The other side don't get the relief. Mostly the cases are in their favor. So you have to. So even I have seen in my personal matters also, like this has been happening in the banks and all. And sometimes there is a ex parte orders also.
Right.
And
Heartless orders are passed. And
so what is the remedy for this?
remedy is that, see, as he pointed out, once you sign the contract,
You cannot do
you
anything.
cannot wriggle out of it unless there are legal reasons. See, how can you get rid of a contract? Either it should be a void contract or a voidable contract. Void means, of course, you can say that. Voidable means you should have a reason to avoid it. If you sign it consciously.
Most of the people don't know what will be the consequences.
But then see, madam, the reason is the other party, if it is a public sector undertaking or a governmental agency like railways and all these people are mightier than the local individuals. So you are actually at their mercy. Once you sign it, you are at the mercy, and law presumes that you knowingly had signed it. It can only be the presumption. Other way around, it can't be presumed
Even
under law.
nowadays there is a judgment, Justice Lalit also, that even there is a provision for sole arbitrator, but that is not proper, and they have asked them.
See, the difficulty probably that will be experienced for pronouncing a judgment that there shall not be a sole arbitrator is that actually there are some, I told him earlier, there are decisions by this court. If I remember correctly, AR 70 Supreme Court or somewhere that area, you will find contract is the realm of parties. It is their discretion whether to sign, or court cannot dissect or bisect a contract unless of course it is severable.
Sir,
Because
but recently there is a debate on this, and there are few judgments whether there has to be a sole arbitrator, whether that's right or not. So you cannot have the sole arbitrator in the contract, and that too from the department. Justice Bhanugati has
I have not read that judgment. Of course, the arbitrator from the department always will be biased to that. That is that is the initial presumption that you can draw.
No, but this thing has been changed.
But then 34 is there.
Muthu, now.
Just to carry forward from what he said, now how far is it feasible to have an arbitrator tribunal in the first place itself? Because most of the times we are saying that it is the courts that are the final authority in arbitration proceedings, because it starts from section 11 itself, appointment of arbitrator.
Right.
And normally in high courts and also in Supreme Court we have seen that there are section 11 petitions filed saying alleging bias against an arbitrator. Now, and also once an arbitration proceedings is concluded before the arbitrator, then again it goes to the district court, high court, then to the Supreme Court. So since it's the courts that are handling the arbitration entirely. So is it time that the arbitration tribunal should be abolished and it should be, the power should be given to the court itself?
Court itself, then the whole purpose will be defeated. See, my friend, please understand one thing. No, see, there are umpteen categories of cases pending in various courts. Forget about Supreme Court, other courts. Take the smallest court in the country. Whatever jurisdictions are there given to them. Or take the district court where section 34 petitions are filed. A district judge is having civil jurisdiction, criminal jurisdiction, human right jurisdiction, then scheduled caste, scheduled tribe. So many, it's about not less than 25-30. So arbitration, if you say that this should be given to the court, this will be only one of the jurisdictions pending it. Then the whole object of arbitration will be defeated. Arbitration, what is the purpose of arbitration? To have a speedy disposal of the disputes without being exposed to the danger of having multi-level scrutiny. Because if you lose in one court, you go in appeal, then second appeal, then of course SLP. Now this level, this hierarchy or this rung has to be abolished. That is the object of arbitration. If you again give it back to court, you will be in a cobweb. You will be completely entangled in a cobweb. So that is not the object. But the difficulty is that Justice Sri Krishna in his report says that even with the 1996 Act, where Section 5 says that minimum judicial intervention is the policy of the Act, still there are provisions in the Act itself allowing the courts to interfere in the arbitral proceedings, like Section 9, 34, 37. So, if that, even, see, because of this, rigid provisions in these provisions in the statute, you have lot of arbitration matters pending here and in other high courts and other places. So, if you give back the original jurisdiction to civil courts, which was failed under 1940 Act, you must please look into 1940 Act, you will find it, original court has to refer to arbitration, then after passing an award, this will be made a decree of the court. So, every stage there will be challenges. So, the whole purpose will be defeated.
I would like to join one issue. This is called the alternative recourse, alternative dispute resolution.
Correct.
But to my opinion, I join his issue. It's basically failed. Take the example. It's a costly. Poor people can't approach on arbitration. Commercial arbitration, of course, it is there. Once award is passed and it is set aside, where you are relegating.
Again back to square one.
Correct. So therefore, judicial interventions are there. Maybe limited, not limited. But in a high commercial matters, I never seen even a single matter for which High Court has not approached. Whether High Court entertain or not, it's another issue. Now there is a institutional arbitration. It too costly. It's basically subsume the courts. They are institutional, they will listing matters, they will decide to whom it will go. Then instead of paying money to them, why not I should go to the courts, which is established by rule of law?
Probably one answer to that aspect is depending on the institute. See, you are beforehand, you know what is the cost that is likely to be involved in an institutional arbitration if you go there. If it is if you read Justice Sri Krishna's report, he says that there are a lot of institutions running for reasonable costs. That is what he has given a list also. I do not know the rate, but
so
he
the
says
rates are fixed as per the amount involved in the arbitration.
that is in the Schedule 4. Schedule 4. No, actually, Schedule Arbitration and Conciliation Act, there is a schedule, 4th schedule, which prescribes the rate. That is only if you go under the Act. Suppose parties go for a ad hoc arbitration, they can bargain on the fees.
Then leave it to their own opinion, and they goes in 10 times what is prescribed in schedule.
Both ones have their own arbitrator, and there is a dispute for the.
Even the payment of fee itself can be a dispute. Payment of
they are
fee.
not in good terms. Everything is bad.
Everything is bad. No, see, cordiality. Once cordiality is lost, everything is a area for fight. No doubt about it. But when you select a private person as an arbitrator, you have the bargaining power to say, look here, I will appoint you an arbitrator, or we will appoint you an arbitrator, provided you demand a fee of this much. If he is agreeable and if he takes up the matter, then that is the end
Correct.
of it.
But when we invoke the court's jurisdiction under section 11 and saying that appoint arbitrator,
Correct.
then their court says that so and so is appointed and fees is on his wisdom. It doesn't follow the schedule what my friend is saying.
No, actually, see, I don't know what is the experience in other high courts. In Kerala High Court, it is a set practice that fee will be provided as fee will be paid as provided under Schedule 4. That will be part of the order. So there is no dispute
This is
for
not
that.
being followed in Delhi High Court.
But in Kerala, that is the usual practice.
Once a court,
No, but this should be in advance when you are getting into agreement or
and
contract.
if you go for
You should decide the arbitrator in advance at the time when
One
you are
second,
put down.
one second, no cross.
That is the right way.
Yeah, please, sir, please.
Actually, I want to understand about the public policy. What is the public policy? What is the against the public?
And see, that is
Wisdom of
please read that SAW Pipes 2003 Supreme Court. You please read that. Justice M.B. Shah's decision.
For example, idol in industry. How to remove the idol from this industry? This is the public policy. Is this public policy or not?
It depends on the view of the perspective of the judge, individual judge. I can't give you
Technically, that is a very difficult.
Maybe I am not
And the second
competent.
question is my also
Yes.
only two questions. I have only two questions. The second question is a judicial mind.
Yes.
A technical officer like a engineer etc. How to achieve the target
Target of what?
for the judgment, the importance of the judicial mind.
No, actually, see, as a judge.
I am suspected about that he is capable or not. Sorry.
Sorry, your question, I did not correctly get your question.
The judicial mind has a correct approach about the judgment. A technical officer like an engineer and doctor and etc.
Okay.
This is my question.
Okay, so then how does he enter a correct finding, judicial finding?
Exactly, this
And
is my
depends, sir, it depends on the nature of dispute involved. Suppose it's rocket industry. Suppose the dispute, how can a judge decide that matter?
Exactly.
So a technician must be there. In that case, probably suppose you find that a judicial pronouncement could not be made by a technical person, then you can have a multi-panel arbitrator where a judge is also, or a lawyer is also a party there.
As well as in court is an expert.
Correct.
Advise.
Make the panel
Evidence
three.
of the expert. Okay.
Go for an odd number.
Okay.
So
Thanks.
Please.
So the purpose of arbitration as a practical purpose, the most of arbitrators are retired district judges or high court judges or civil servants. And the attitude of their the practice is the purpose of shortest time, the delivery justice system is not been delivered.
Right.
That what are your suggestions for addressing that issue? And other thing is the major stakes matters of high stakes. Many companies are going internationally like Singapore or London. So now a new center is being proposed and it is just started in Hyderabad.
ICADR,
Just
Hyderabad.
throw how it will be advantageous for this arbitration to go in a big space and will it give a fulfillment of any push
Okay.
to the purpose of
Okay. What I understand is that ICADR in Hyderabad is only for international commercial arbitrations.
the new center. The new,
That is only for
That's
that.
the new center only.
Then domestic arbitration, we are concerned about the domestic arbitration in the question. Domestic arbitration, you find there are a lot of centers, that is what I was telling, about 35 or so that this Sri Krishna enumerates, but even maybe more than that, we do not know. But then as you pointed out, see, in every court, of course, district court they don't have, high courts, every high court there will be a panel of arbitrators. As a previous judge of the Kerala High Court and I was involved in that jurisdiction, I can tell you that a panel consists of retired judges, senior advocates, then engineers, chartered accountants, and so many other walks of life, persons from different walks of life. And of course, it is the party's choice. Normally, when a matter is technical matter, for example, it comes up for consideration before the court, and the parties insist that an arbitrator, 3 arbitrators, panel of 3 arbitrators must be appointed. Then of course, it is their choice. We will provide the panel, you find out which one is suitable. Or if the panel, the persons in the panel are not suitable for them, both parties are free to suggest, give a panel of their choice. And if both sides agree on the panel, we will find out one from that. So that is not a difficult exercise actually. But see, the what you call panel or the names of kept in the body, judicial, courts, may not be always perfect, or it may not be complete. When situation arises, we go for that, get the suggestion from the parties, so that let it be a transparent thing. Why should we impose, especially when they choose a private arbitrator for them?
Sir,
Please.
if we talk about international commercial arbitration, as you said, in Asia, Singapore is a hub, and even like many arbitration dispute, they take place in Singapore. Indian companies involved in with MNCs and all. So don't you? And in Singapore Arbitration Center, SIAC, CR, the president is Mr. Gary Bond and Mr. Toby Landu, the next in the line. Sir, don't you think like if we are making international arbitration centers in India, so we are not following that approach like of being more inclusive, like getting more arbitrators from abroad and in the panel?
Actually,
Because in LCIA also, American Arbitration Association, America also, like they are more involving
in
worldwide.
India we don't have that involvement.
Yes, sir.
That is one of the
Yes, sir. I
deficits
believe
in
sir,
India.
it's not just the infrastructure where we are lacking.
Infrastructure
but the
is not
approach.
the only issue actually. As you pointed out, exposure to international practices, exposed to this, lack of persons capable of handling international disputes. Even as you pointed out, foreign experts also can be empaneled here, but that is not happening so far.
Yes.
Maybe one day or other in the near future it will happen. That is the wishful thinking probably one can have.
Yes, and that will promote
Absolutely.
party autonomy also.
Absolutely.
Which is the core of arbitration.
No, see, every day you find from newspapers, all the bureaucrats, all these administrators, all this constitutional heads of the state, they say that we should open up the market to the whole world. So, if you invite persons to invest in India or do business with India and it's the companies or entities functioning here, then certainly there must be a what you call method to resolve every business. There is a likelihood of a dispute. You can't do a business without a dispute, possible dispute. So if there is a possibility of dispute, there must be an effective resolution method also available in this country. As you suggested, it is essential that we should have such a larger scale this thing for resolution.
We should open up.
We should open up. That is what this idea is carried in Justice Sri Krishna's report.
Thank you very much, sir. Very nicely, patiently you explained everything. Institutional arbitration and ad hoc arbitration, merits and demerits. Nice to hear, and even the first time we have introduction from you. It's thanks, involving yourself, asking several questions. So thank you very much, sir.
Thank you for the opportunity to talk to you all. Thank you.